Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. All right, today we're going to take a very somber and sober look at one of the often repeated defenses of Mark Waid that might be attempted should this thing go to trial. Let's see if it's valid and let's analyze it. The truth is the asserted defense that Mark Waid was simply contacting Antarctic Press and providing truthful information about Richard Meyer, that the First Amendment protects truthful speech. Okay? This is going around, we'll say, going around. Can I say jokes? I feel like if I say jokes, people won't take this seriously, but it is. They need to know this because they have to know what the reality of the situation is. So, I won't say jokes. I probably will. Let's get on with this. So the idea is that Mark Waid calls Antarctic Press and offers him truthful information which is protected by the First Amendment. There are a couple avenues to get to this defense, and let's look at each of them. I have the document pulled up, and here's why. One of the ways that you assert truthfulness as a defense is if truthfulness is a defense to an underlying tort that is tied into tortious interference. For example, defamation. Now, if Meyer were claiming that Mark Waid contacted Antarctic Press and made defamatory statements about him, and that those defamatory statements caused a tortious interference, then presumably you would be able to argue that the defamatory statements are truthful and not defamatory. And if they're truthful and not defamatory, then they don't lend to the underlying tortious interference of the contract, because the defamatory statement would be unlawful. Let's see. The key element of this is that the tortious interference must be linked to the defamation. Let's look at the causes of action. Let's refresh our memory. Tortious interference of the contract. Meyer had a contract with Antarctic Press for the publication of his Jawbreakers and other comics books. Waid either had knowledge of the contract or had knowledge of facts and circumstances that would lead a reasonable person to believe there was a contract in which Meyer had an interest. Though through the actions described above, Waid intentionally induced Antarctic Press to breach its agreement with Meyer. Waid's interference proximately caused injury to Meyer, for which he seeks damages in excess of $75,000. Okay, we'll go look at the actions above in just a second. Let's read the defamation paragraph real quick. Defamation. Through his various social media accounts, Waid intentionally published statements of fact to his followers and the general public regarding Meyer, including falsely stating that Meyer published the first and last names of comic book store employees to encourage his followers to harass and threaten them, as well as characterizing Meyer as a racist serial harasser of minorities and as affiliated with white supremacists. Those statements were false and were published with actual knowledge of or reckless disregard for the statement's falsity. Those are separate things according to these two causes of action. One is Waid interfering with Meyer's contract. The other is Waid simply publishing false statements about Meyer. It doesn't assert that he published those statements to Antarctic Press and that those statements were the basis for the interference with the contract. So let's go up into the facts section and look at what they said. Let's see. Okay, here it is. Paragraph 17. This is where the interference starts. That same day, rumors and leaked chat transcripts suggested that certain retailers aligned with Waid and his followers had agreed not to carry Meyer's book and to boycott Antarctic Press because of the misinformation being spread about Meyer and his views. Initially, Antarctic Press was not flustered. Notice, the defamation is detached from Antarctic Press's decision at this point in the paragraph. Instead, Antarctic Press responded, "That just shows me we're doing the right thing standing with you." That's evidence that the defamatory statements are not the cause of the breach of contract. This is important. Later that evening, Antarctic Press publicly announced on its Twitter page, "It's official, we're publishing Jawbreakers in September." Less than 36 hours later, Waid tweeted to his followers that he was going to contact Antarctic Press to interfere with its impending publication of Meyer's book, saying, "I have a call into Antarctic Press. Until I hear back, I'm hesitantly willing to give them the benefit of the doubt. They don't really understand who or what they're getting into business with, which, though it would seem a stretch, is a possibility. If I do hear back, I'll report in." On information and belief, this triggered an onslaught by Waid's followers against Antarctic Press, with calls and threats to Antarctic Press and its owners' other unaffiliated businesses. Later that day, Waid spoke by telephone with one of the owners of Antarctic Press and convinced him that Antarctic Press should repudiate its contract with Meyer. Frightened for its very survival by Waid's threats, and primarily because of his unwelcome interference, Antarctic Press caved to Waid's pressure and issued the following statement. Notice what's missing from all of this. There's no "because of Waid's defamatory statements against Meyer." The allegations for defamation are separate from the tortious interference claim. So even if Waid is able to defeat the defamation claims by alleging that they are truthful statements or unactionable opinion statements, that does not defeat the underlying tortious interference claim, and truth is not a defense in that circumstance. Truth doesn't attach to TI because there are defamatory statements. Truth attaches to TI because the defamatory statements are the cause of the TI. That's not alleged in the complaint. I won't read their statement because I don't want this to be too long. Almost immediately following Antarctic Press's announcement, perhaps having been warned that his interference was actionable, Waid deactivated all of his theretofore quite active social network accounts without explanation. So, that's one theory. That's a theory that if they can defeat the defamation claims, then the tortious interference will go away because truth to the defamation claims would be truth to the TI. That's not valid. Next, let's get into the small matter. Let's get into the small matter of how Texas law looks at this defense in general, okay? So there are these things out there called restatements. Restatements are where a group of lawyers get together and clarify the existing definitions of law based on definitions of common law based on how courts have been ruling and evolving common law. So there's a first restatement of torts, there's a second restatement of torts, and there might be a third restatement of torts, and if not, they're working on it and they have portions of the third restatement done. In the second restatement of torts, truth is a defense to tortious interference. Truth of the statements can lead to a privileged defense, or truthful statements may be privileged under the second restatement of torts. This is important, though. Just because it's in the restatement doesn't mean the jurisdiction recognizes the restatement. Texas has not adopted the second restatement of torts. Texas does not follow the second restatement of torts, and Texas does not apply truth as a defense to tortious interference with a contract. Let me just go ahead and show you if I can. Here we go. This is from okay. Let me clarify this before someone comes out and tells me that I'm trying to hide something. Okay. This note is from a case called Hanson versus Jackson. This is from the Court of Appeals in Texas in 2014. Okay. This case has been overturned. Please don't make the mistake of thinking that this paragraph isn't relevant because a case was overturned. That's not how this works. I'll talk about the case that overturned it in a minute, okay? But listen to this. Regarding the second ground, PSC asserts that it conclusively established the defense of privilege based on truthful information. Neither this court, the transfer court, nor the Supreme Court of Texas have ever recognized that a person is privileged to intentionally interfere with an existing contract by proffering truthful information to a contract party. Let me read it again, because everyone seems to misunderstand this. All of the Twitter legal experts out there commenting on the case. To be charitable to them, they're probably not aware of how Texas treats TI claims because they're not researching this, because they're not Texas lawyers or very important YouTube lawyers. Regarding the second ground, PSC asserts that it conclusively established the defense of privilege based on truthful information. Neither this court, the transfer court, nor the Supreme Court of Texas have ever recognized that a person is privileged to intentionally interfere with an existing contract by proffering truthful information to a contract party. PSC provides us no reason to recognize this defense to tortious interference with an existing contract, and we decline to do so here. Now, that case was overturned. It was overturned by a case called Community Health Systems Professional Services Corporation versus Hanson. This went to the Supreme Court of Texas. It's the same case. It's the same case. PSC is Professional Services Corporation, okay? Now, this was overturned, which means the verdict changed. The verdict was on summary judgment. I can really go into a deep dive on this, but it's not important. What you need to know is this. I don't have this clip on the screen, but let me read this to you. Although the Court of Appeals properly held that the trial court could not grant PSC's motion for summary judgment on no evidence ground, the Court of Appeals erred by reversing the trial court's summary judgment order based on a mistaken impression that PSC had not conclusively established its justification defense. Listen to the next sentence before you cheer here. Therefore, we need not reach PSC's arguments relating to qualified privilege and privilege based on truthful information. So, PSC has argued that truth is valid to establish privilege in tortious interference. The Texas Supreme Court overturned this on other grounds and does not reach that argument in this ruling. Further, in footnote 13, let me read this to you. PSC also asserted that Dr. Hanson's tortious interference claim was barred because it turned on PSC's communication of truthful information and advice to REAP. REAP is an acronym. An affirmative defense to tortious interference under the Restatement Second of Torts, which this court has not adopted. The Court of Appeals rejected this theory. The Court of Appeals also held that summary judgment could not be upheld on the ground of qualified privilege because PSC's summary judgment motion did not specifically invoke the defense in its discussion of tortious interference, as opposed to its invocation on Dr. Hanson's business disparagement claim. We do not reach these grounds for summary judgment in light of our decision on PSC's justification defense. Okay? So Texas, the Supreme Court of Texas, and this is June 16th of 2016 that this opinion was published. Texas does not recognize truthfulness as a defense to tortious interference claim. Even though it's in the second restatement of torts, it has not been adopted by Texas Supreme Court. They had an opportunity to do so, and they specifically refused to do that. So, if you think that the truth, if you assume that what Waid said was truthful about Zach and that truth will set him free. That is not Texas. Texas cares more about contracts than that, and they don't want people meddling in them, even with truthful information. Part of the problem with truthful information is you can give a true opinion that would be defamatory if it were a statement of fact, but since it's an opinion statement, it's non-actionable. That doesn't make it okay. And I think that's probably a big reason Texas has not adopted truth as a defense to TI. Because if you allow truthful opinions to interfere with contracts, then what are you protecting? What are you protecting? All right. I don't have anything more than that. I don't have anything more than that. No, I'm lying. I do have one more thing. One more thing that people are throwing around is the idea of justification. Because they're saying Waid was justified in contacting Antarctic Press. Okay. Justification, very briefly, is a legal term of art in regards to tortious interference. It is an affirmative defense to tortious interference if you have justification. But justification is the exercise of a right under the contract, okay? Not an exercise of like a First Amendment right, not an exercise of any other just ambiguous right or undefined right or even an enumerated right. It is only an exercise of your right under the contract. So a third party who has no rights under the contract does not have a right for justification. All right. Now, there could be a third party beneficiary. There could be a principal agent relationship. There are third parties to contracts that will have rights under the contract. Mark Waid, based on everything we know, is in no position to have a contractual right to the under the agreement between your boy Zach and Antarctic Press. There's no information provided that Mark Waid is somehow involved. He's not an employee of Antarctic Press. He's not a board member or something like that where he would have some sort of third-party status that would have rights. So, the other possibility for justification is if the third party believes they have a colorable right, but is wrong. They believe in good faith that they have a colorable right, but are wrong. So, for example, you believe you're a third party beneficiary, but it turns out that you're not. Or you believe in good faith that you have a principal agent relationship that would give you some sort of right under this contract, but you're mistaken, but you have a good faith belief and you're holding yourself out as a principal agent relationship, then you could assert a good faith justification defense. We have no information to suggest that Waid has any of this at his disposal. So don't be misled by common use of justification. There's no white knight provision in any Texas case on tortious interference that I've found. I went through the key sites on Westlaw. There's no white knight provision. There's no truth is a defense provision for any of this. It doesn't exist. It is a novel argument. No, it's not even a novel argument. You're asking the court to adopt a new legal standard that's been refused before as recently as last year. So this isn't some little thing. This isn't something, oh, we just got to get the court to catch up and they haven't had an opportunity and now they're going to have a case. Texas has refused to do this for quite some time. So don't be misled by the common colloquial use of justification. Don't be misled that truthfulness is a valid defense to tortious interference in Texas. It is not. If Waid were to win under this, your boy Zach would actually have strong grounds for an appeal because it would go against existing precedent in Texas. I just need to put this out there because there's a lot of confusion. And there's a certain lawyer in Washington, D.C. who doesn't want you to know any of this. And when people start asserting these things, he will call them non-lawyers. And when all sorts of comic professionals start asserting these potential defenses, and you explain politely or impolitely, as it may be, that that's not a valid defense to tortious interference in Texas, which is where this matters, they don't know what to do with it. They don't believe you. It's a bias thing. Oh, they're just biased. Blah, blah, blah. They don't confirm my bias, so they're biased. No, it's just the law. And no matter how many people someone might call a dummy, no matter how many idiots they might call dummies, that doesn't change what the law is. That doesn't change any of this. This is the law in Texas. This is what Waid is up against. And I can't tell you enough. He's got a long road. No matter how many tweets per hour his high-profile Libya-destroying attorney produces, Waid is putting on, or Zaid, I guess, is putting on a strong face for Waid because that's his job. That doesn't mean he's got a good case. He doesn't. He doesn't. Thanks for watching.